We are back in the Senate Judiciary and we're taking S12, our sealing and expungement bill. And first we just start off with Matt Valerio.
Hello, I'm Matt Valerio. I'm a Defender General and here to talk about. Sorry. Be able to see which. Five years ago, I didn't have these impediments. No, I was good. I have various general thoughts about the bill, which I think are important, and really starts with asking the question, why? What is what's the point of this? Why is this being proposed? I don't understand it. I see in the little preamble that it's supposed to make things less complex. I didn't see that. The bill does away with a process that's been available since the 1970s without any dispute or particular consternation by anybody, which is expungement for deferred sentences. In fact, 10, 12 years ago, maybe it's more than 10, probably 12, 15 years ago, there was a bill passed that some prosecutors thought the sky was going to fall when it was available to defense counsel and lawyers to get expungements over the objection of the state's attorney in particular cases. Thought they'd be flooded with them, and it'd be an awful situation. Of course, that didn't happen. We file motions in the appropriate cases. The bottom line is expungements for this is one of the big issues in this for me, is expungements for deferred sentences have been available, for 50 years or more, and it's an important tool both for prosecutors and for defenders. Want to change that? What's the point? I don't believe in change for change's sake. I think you need to have a reason, especially for something that has not been controversial, something that has not been in dispute and has offered benefits to both sides, meaning prosecution and defense, and a real benefit for defendants. One of the things that there was a study in Michigan about the difference between stealing and expungement. And the Michigan study showed that within 3 years of receiving expungement, the average person who had received their expungement, that average person's income grew by 30%. When compared to sealing, there was no such benefit. The bottom line is what expungement does is provides people who have kept themselves on the right side of the law after getting mixed up on the wrong side of the law, the opportunity for a fresh start and a clean slate. And isn't that what we're really about? I mean, we understand that people do bad things and that people make mistakes and have poor judgment. And some people are just bad, some people aren't good folks. But what we want them to do is to stay on the right side of the law. And if they've demonstrated that they can do that, that's exactly what we want. We also want them to become productive tax-paying citizens, to get better jobs, to be able to become professionally licensed, to be able to be positive contributors to their community. And I can go through my 37-year legal career and talk to you about individual clients who've had this benefit of expungement and have come out the other side. And, I can literally tell you about people who I had no belief that they would ever really be successful, but they had this opportunity and they became billionaires. You know, I know of, you know, it was a kind of, um, hilarious and notorious client in Rutland who ended up on one of those stupid shows in the nineties where, you know, America's dumbest criminals, and he and his girlfriend went around breaking into camps and houses and taking things, and she videotaped them the whole time. And when he got convicted, she sold the tape to the show for 20 grand or something, and ultimately, you know, it was a national situation, you know, all over TV, and both of them, both her as an accessory and him as the main perpetrator, I guess, ended up having the benefit ultimately of expungement. He became a very sickly, quit drinking, quit doing any kind of drugs, and his drug of choice really was alcohol, but he liked it a lot. And you know, she was right at the time, right there with him. But you know, he went on to found a roofing company, a construction company, and literally made millions with this construction company. He passed it on to his son, who's doing it now, and she went on to, you know, get married, have kids, and live a productive life. Both of them contributing members, and part of this, there, you know, they once they got past those early years of, you know, 18 to 25, turned into productive citizens. And you know, when this guy who has moved out west and getting licenses for, does a whole bunch of contracting type stuff, but his record is expunged, and you aren't gonna find it. So he became a legitimate guy. There's another guy who was involved in when he was 17 years old or 16, 17 years old, one of my former clients involved in a stabbing case, that was in a brawl, and he ended up getting convicted of an aggravated assault, sentenced and to 1 to 10 years, but never had any problems with the law after that. And because he was underage like that, he ended up getting expungement, and is now a head like EMT type guy, licensed through the Department of Office of Professional Regulation and the like. And I don't think those, and ultimately it took literally 30 years to get the expungement taken care of, ultimately with the stipulation of the state's attorney. And the bottom line is, you know, it took him that long, but he can do things that he always wanted to do that he was prevented from doing, which is coaching kids. And, you know, he got married, had a kid, works as a first responder for ambulance and the like. These things are not available to people when they have their criminal records available to the Office of Professional Regulation and the like. The bottom line is their expungement is not a dirty word, and it's not a bad thing. It's a carrot that provides the people who are willing to do the right thing the ability to get good jobs, live productive lives, and become the type of Vermonter that we all wish they were when they were younger, or the like. And I don't know why that needs to go away. The evidence, at least from the Michigan study, is pretty clear that there's financial benefit, which benefits the state from a tax-based standpoint, and the like. And it doesn't happen with all of them, you know, because people fail. People don't get out of their alcohol situations. They don't get out of their drug situations. But there are a lot of people who do, and that benefit should be there for people. The idea that the bill as drafted is exactly less complex. I'm not buying it, aside from the fact that you change, you know, effectively expungement is gone and you just use the word sealing instead, but then make it available to more people than we ever have before. And then you have a whole list of things where it's not available to, and you're still parsing through all the things that are excluded and not excluded, that are available. It's equally as complex, except you don't use the word expungement. So, to me, it doesn't, I know the preamble is not the be all and end all for the purpose of the bill, right? But it doesn't do, in my view, as far as solving complexity, it doesn't do anything except for eliminate expungement.
Matt, if I could, I take your point that the bill sets up a complicated system for who can get sealing and who can't. And also there's a new regime about who can see it and who can't. But it is simpler in the sense that they don't have to destroy records and hunt down records and manually expunge them. And that's in large part why I think we're here. So your opening question was, what are we doing? And I echo many of your concerns, but it seems to me that the abiding problem with the expungement regime that we created is that it's just in its practical features on the ground in terms of the amount of time it takes and the backlog that is building up as a result. That's to me true complexity. Whereas what you're talking about is a complexity of whether something is eligible. Once that decision's been made, it's simpler, it seems to me.
My understanding is the testimony of the courts didn't take them any more effort to expunge than it did to seal. That was Harry Corson's testimony, and
I
so
don't remember that.
that was.
I remember them talking about the hundreds of hours people spend with, different records, literally physically getting rid of the evidence, as opposed to changing a computer setting that.
I mean, I don't know. I watched the testimony, and she was asked that question, and she says there's no difference. So, I think it might put other burdens on other people, maybe law enforcement or the like, but from a court perspective, the bottom line is both sealing and expungement is something that's gone on in the courts for decades. They know how to do it. And I wonder, beyond the complexity, what benefit this has provided.
Matt, I have a few questions. The expungement that's been going on for 50 years, that's been 50 years of our state government just completely eradicating and denying the existence of those records after they've been expunged.
Right. That's the deferred sentence.
And the Michigan study, I'm assuming it took in, I haven't seen that study, but it's looked at other states as well.
It looked at what was going on I know it looked at what was going on in Michigan, and the impact there. And actually, I know you're going to move on this bill quicker than you're going to care to see that. But the bottom line is, that's something that's producible.
My understanding is that we are the only state that engages in the practice of completely deleting and denying the existence of records after we've taken action against a person. And so I don't know, I'm curious about that study, because if there are other states that have, what they refer to as expungement, but it's actually just sealing.
Or something more like, this is where we get into the semantics of what these words mean, right? Mm-hmm. So some of them, other states, New Hampshire, for example, does a lot of expungement, and nothing is exempt from expungement if you qualify under their statutory. And it's not exactly the same as one state's is not exactly the same as others. I hate it when we get into these qualifiers or super sealing or expungement light or whatever it is. So I don't know that I agree that no state does what we do. I think that other states go farther than we go when it comes to eligible crimes for expungement, whether it's expungement or super sealing, or what does sealing mean in any given state. As far as I can tell, in some ways we're actually behind of many of our neighbor states.
So there are other states that completely delete the record and then deny their existence?
I can't say that specifically. I know that expungement means you can deny the record's existence. And you're actually required to deny the record's existence, and you're required not to comment about whether they exist or don't exist. It may be just one of those things. What do we do with processing? We'll take it all off the public record. We don't have to go through the process of shredding the file or whatever, but for all purposes, it doesn't exist. So if somebody asks you about it, it doesn't exist. They could hold it to you and say that doesn't exist. The bottom line is, as a matter of law and as a matter of your ability to comment to anybody about it, it doesn't exist. The issue is the mechanics of, do we actually light it on fire, or do we shred it, or do we, throw it in a dumpster somewhere and, bury it in the landfill? I don't know the answer.
So I also wanted to clarify, you had talked about OPR, that entire section regarding licensing and employment, that we're taking that out. We're not opening the floodgate to, letting some employers see it and other employers not see it, because that does defeat the purpose that I believe the committee has agreed upon, which is that the whole idea of this is to give people that chance to get employment.
I try not to get too involved, but I will say the elimination of, I don't know why I keep coming back to it, because I've said it enough, but the elimination of expungements for deferred, to me, is just, that's an unnecessary egregious step with something that there was nothing wrong with to begin with. And it's going on forever. Even the part where the defense counsel or client could ask for expungement over the objection of the state's attorney. It's used not that often. It's used in appropriate cases. And since it was passed, I don't hear complaints about it. The complaints started to arise as we started to expand sealing. And now it seems like there's some opportunity. I don't really know who's pushing this, to be honest, but because of changes in sealing, it has opened the crack in the door to go after expungement. And I don't understand it.
So this is not, I'm having a hard time following what you're saying, because it seemed to me that the complaint started with expungement, not with sealing, that we expanded the expungement regime and, greatly expanded it. And again, required, as the chair said, this complete physical removal of the records. And going back the last 4 or 5 years, well, the whole time I've been on the committee, 6 years maybe, the testimony has been that it's that piece that's overwhelming the system, the physical eradication, not necessarily sealing records. But maybe there's a piece that I was misunderstanding during that time. But
I think there's a confluence of these two words going back and forth. The expungement portion, I think expungements for deferreds should be a whole, to me, it should be off the table. If you want us to talk about expungements, other things that might be causing a problem, talk about it. Part of what I'm doing is I unfortunately have this legislative history in my mind about proposals that happened in the House in the last year or two, and positions that administration took over the last year or two. And this bill goes beyond even what the administration was asking for regarding shrinking available sealing. There was, if expungement needs to be shrunk to some degree because of problems with that, or what do you do once expungement occurs? If this is about, we don't want to be shredding everything and going through every sheet of paper, then don't make expungement available. Say, as a matter of law and a matter of reality, we can electronically, according to Terry Corsones, eliminate by expungement or by sealing. There's no more effort for the court to do that. And with the hard files, they're to be, they don't have to be shredded or whatever. They just have to be, taped shut and ignored as though they don't exist. We in Vermont are unique also. And there was a bill that actually passed a few years ago I know it came out of the Senate. We don't have things like second look or sentences. We don't have things like sentence reconsideration after the first 90 days. We don't have these options that are all over the country when it comes to giving people second chances to prove that they are contributing members of society. We have what we have when it comes to sealing and expungement. If people had other opportunities to address either their sentences or whether it's second look, those types of things down the road, we kind of shut the door on people really early if you don't have sealing and expungement. And that's kind of their carrot with a stick at the end of it if they don't qualify. I mean, to qualify for sealing or expungement, there are certain things you have to do, certain amount of time frames that you have to go through without being convicted of another crime. And some of those are longer than many people would think is appropriate. But it's all part of, to me, part of the bigger system of making sure that people have second chances to become productive and that they're not bound by what we refer to in elementary school as your permanent record, to me, people deserve second chances. The way we've looked at like deferred early injection of state's attorney at that age, was it 26 is the top where you can ask for that kind of thing. Then there's various stages along the way. I just don't like seeing, honestly, younger people who get themselves in trouble when they aren't thinking well, whether they're on drugs or they're just not mature enough or they have poor judgment, being effectively trapped by not being able to get good jobs, not being able to get apartments, not being able to be successful when they've grown out of those early years of problems. Anything that kind of attacks that, to me, is an issue. I see this bill as doing that with if you're getting at the physical destruction of files, let's deal with that. Let's deal with what is it that we need to do to make sure that we aren't burdening people with, shredding hundreds of files or whatever they do with them, as opposed to getting rid of the whole class. There are other kind of collateral issues that kind of go with making, what's the point of a sealed file? Basically, all the people who, might want to look at it, honestly, what is the benefit? Tell me, former law enforcement, right? What's the benefit of having somebody at the roadside see a sealed file?
Well, we've had those discussions, Matt, and as of right now, there's benefits and non-benefits. So we're not quite sure that we agree upon using that example as something that should be in this particular bill. We haven't talked about it as a committee as of yet.
Well, it's just an issue I'm bringing up. It's something to be concerned about. And I'm not saying that everybody who has a sealed record that gets pulled up on the roadside is going to get profiled, but it could be.
So,
they're just these potential collateral consequences to doing what's in this bill that aren't there right now.
Yeah, the value, I mean, I don't think a cop 15 years later is going to, I don't think a cop is going to look at a 15 or a 10-year-old sealed record and, say, yeah, gotcha on that. But I think that, well, I mean, yeah, to provide some additional background, I mean, the reason that in conversations with Rep. Loans, the reason that I wanted to take this on is because, what I heard over the summer, primarily from lawyers who work in criminal defense, is that the current system is very problematic, even though it's well-intentioned. And that was a surprise to me, but, after practicing and seeing, where the bumps in the road are, I'm starting to get it. So, I don't understand how it could have an impact on somebody if the only people who can access a record are the state's attorneys or that person's defender years down the road. If they are, if they're a witness in a case, or if, a number of years later, they're tied up in an extremely complex case, or perhaps if there's an investigation into a cold case, or if they find that, the prosecutor who was prosecuting them was corrupt, or if the police officer was, stealing things when they were executing search warrants, and, and the defendant wants to get that information, years later when they realize this. So,
Well, you make a supposition there that's not the law. And I think that the defenders have never counting. Well, I've had this conversation with, once I talked it through with them, they're like, oh yeah, I guess that's true. First of all, the file that the defenders have is not their file. It's not the Defender General's file, it's the client's file. So those files are not destroyed. The files are owned by the client as a matter of ethics. So anything in those files, like case law, like witness information, and the like, if it comes up again, is accessible to that. It doesn't go away because it's not a government record. It's a client record. The other thing is, and I don't think that, we've had this conversation with some of the folks down in your area, down in Wyndham. They're putting the needs of themselves as lawyers ahead of the needs of the client. In these cases, what makes their job easier as far as access to cases and what the consequences of stealing or expunging would be to them, not the client. Our job is to put the needs of the client ahead of the needs of the lawyer. And that is, I think that's a flaw in what I understand what they're saying.
so so if I have a client who has been, and there's an alleged victim, and I get information that the alleged victim has a previous record that has since been expunged that shows a history of violence and prior bad acts, and I want to use that information to support my client. I disagree that it's, prioritizing how I'm working as opposed to prioritizing.
Well,
what's
not
best
every
for my
single
client.
instance is that, but in that particular case, prior bad acts are available from any source. It doesn't have to be from the court record. So what I would do in that case is I would send an investigator out to talk to the person and say, hey, were you the person involved in blah, 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 blah. The facts and the incident don't go away. The record goes away. So while you might not be able to use the expunged or sealed record, doesn't mean you can't go out and document the facts and use those prior bad acts in the case going forward. And in fact, from my perspective, in the cases that I've done over a period of time, that is much stronger evidence than the evidence that is in the record, which is just, hey, you were convicted of false information to a police officer 10 years ago. You know, no, you bring in the people who actually were involved in the prior bad acts. You get statements, you get you get real testimony evidence, and you offer and prove those prior bad acts. You don't do it by the record. It's just it's stronger evidence, number one, and the fact that your memory of it and the fact that it exists in a file that is not a public record is just your I'm not finding the right word, but it is your the way you get to there. Bottom line is you don't forget your cases, and the client and the files are the client's files, not yours. It's not the state's.
Any questions? Sure, Mark.
Yes, I do. Going back to the Michigan study, man. This is kind of a two-part question. So are you saying that Michigan only has the expungement process, or do they have both?
As I understand it, they have both, but the expungement produced a better result when it comes to income within after 3 years of receiving the expungement. The finding was that within 3 years of receiving expungement, the average person's income grew by 30%.
So did they have access to the sealed records in Michigan?
I think this is why I would hope that Marshall would have ended up talking about some of the details here. I see things more from a 30,000 foot view, but he can tell you more about that study.
I would assume that they did a study. I'm a little confused as to when they do a study on expungement versus sealing, if the records have been expunged, how they do a comparison to the sealing process. In fact, the records have been expunged. Where does the data come from if the records have been expunged?
Well, in the old days, when you ran a criminal record check, and I don't know what it looks like right now because I haven't looked at one in a few years, but say you had a different sentence and your record was expunged, it would say state versus citizen, and then it'd just say expunged. So you keep track of what the name of the person who was expunged.
Well, the study, it says it was done in 2020, or the publication date, I'm sorry. So I don't know. I'm just confused as how they, not you, but how they did a study on.
You should ask them.
I don't know.
I think Marshall would know more about it. I mean, I can only look at, what I can find in research and depend on my people who do the research to give me information here. That's
just somewhat ironic. We come from this expungement and no one has access to the records.
Well, I'm sure that
compare
they didn't make
expungements to sealing.
I'm sure they didn't make it up. They didn't just say it.
Did they have access to the expungement records?
They must.
Can I just interject real quick here? So I'm looking at a prosecutor's office in Michigan. In their guidance, they say to the public, it is important to know, though, that expunged does not mean permanently deleted. Your expunged offenses can still be seen by law enforcement officials, prosecutors, courts, the governor, certain agencies like the Michigan Department of Corrections. And what they do emphasize is that it is hidden from public view and you don't have to list it on your application for employment. And they also talk about the 22% increase in wages for folks who get their records expunged or sealed or whatever you want to call it.
This is where the semantics of the words make a difference.
I don't know if it's semantics. I mean,
well, you can call it a duck, but if it doesn't walk like a duck, talk like a duck, it ain't a duck. You can call it expungement. It might not be expungement that we look at it as, but it's also not sealing the way the bill was written either. So, it's somewhere in between there.
I mean, it seems like the sealing that we're looking at is quite similar to what Michigan does, and that certain government agencies can still see it, but you are allowed to say on your employment application that you have not been convicted of an offense, and I think they still have the same 7-year as well. So I don't know if that's semantics, but
Well, semantics is about definition, right? That's, I read the bill as drafted, and it included more than that. Now you're telling me OPR is going to be out of it and the like. And the other thing is, honestly, I don't want to be negotiating a bill here, but the bottom line is eliminating expungement for deferred strikes to me at the heart. That's a problem for me. That's not consistent with tradition, precedent, promises that we've made to people in Vermont for 50 years, where if you get a deferred sentence, you do the right thing, then your record's expunged. And
I think we can definitely revisit that. I'm not saying it's off the table or anything. But
I mean, we're not even out of this committee, so I get it. But if it's okay for those, are there any others that it's okay for? If you go whatever the number is, 7 years, 10 years, whatever it is there a time when people should not have to worry about their physical files or anything else being discovered by anybody? Is there a time when it doesn't matter anymore? Was there a time for the dude in Rutland who had the construction business? Was there a time when the 17-year-old with the stabbing where he didn't have to worry about that anymore? I think so. There's a time when it's not the same person, it's not the same place. They don't deserve to have those things seen by anybody or available to anybody. That's my opinion.
Sarah,
Yeah, thanks, Matt. My question, because I actually used to very much be in the space where you're at, where we should just keep expungement as it is. And the one place where I was able to sort of come along and see the value of hanging on to it was in the instance that the person for whom the record applied to wanted to see it. And so that's a little bit of a shift in that it's not totally deleted, it's there, but only if the person whom it applied to wanted it. And I wonder what your thoughts are on that.
Well, this is one of those things that's interesting to me only because their file they could always go to their lawyer who has an obligation to preserve their files ethically, or if you're a public defender client, we have an obligation to preserve those files because they aren't ours. They are property of the client. They can always get that. I don't have any problem in general with the concept of people having their own. But there is a way to do it. It's just people don't know how.
Right.
Because it doesn't go away. It doesn't just disappear. Because it's not a state record. We just have an obligation to store them. We have I think our disposal thing, because there's no statute of limitations on like post-conviction relief or that kind of thing. So we effectively have to keep files for 100 years because most people would be dead by then. Then you can get rid of them. Or if the client gives you permission to get rid of them. File storage. We're going, and also now our new case management system that's within the primary public defense and contract and DAP system. Almost everything is becoming electronic. So if a client says no, get rid of my file, you can do it. It's the ones the past ones, that were on paper. Those are the difficult ones, and most don't ask for it. So, but anyway, there's probably said enough. Unless you have more questions. Anyway.
anything else? Yeah, great. Well, thank you.
Yeah, thanks for having me in. I think if you want to pound down on that study, Marshall's the right guy to have in on that. But you know,
I just find that, I mean, even what the charity is right there, these people in Michigan, you know, if you have access to an expungement or state's attorneys, is it expunged or is it not? I mean, we talked about having access to the sealing records, but what kind of expungement there?
In their guidance, it said if your record is expunged, then it is sealed from public view. So it's just, that's the semantics of it.
Okay.
well, it's the definite, what does expungement mean? And I have no problem, honestly, with, if the big issue is people who want to be shredding files, then don't shred the files. If that's a big problem, time-wise and effort-wise, then don't do it. If the court doesn't want to shred their files, don't shred them. Wrap them in duct tape and stick them somewhere that nobody can get to.
I just thought that they realized it's up to the state or the vendor to maintain these records for an extended period of time. However, they still are supposed to be expunged. And the only person who should have access to them is the so-called the person accused of the crime or whatever. So we start saying that all these other entities have access to an expunged record when it's not the definition I thought we were talking about here. So anyways, not something about that.
I don't really want to be Michigan.
I don't either. They got good deer.
They had a lot of good, but you know, still don't want to be Michigan.
Go on. Thank
Thank you.
you. Appreciate it.